Harris Mendez,
Present.
Tom Butler,
Here.
Catherine Rosewald,
Here.
Robbie Shaw,
I'm here.
Deborah Yurko.
Present.
We do have a quorum present. With the recent announcement of the governor of our two new commissioners, we do have two new ones, but unfortunately, we're not able to make it today due to the short notice, but we do expect them in our June meeting. So we'll have two new commissioners, Rick Figueroa and Helen Collier, that will be joining us in June. So we do probably want to congratulate them when you see them. We'll now take up item C. We'll go into executive session. Consultation with staff attorney pursuant to section 5510711 of the Government Code to receive a briefing from general counsel concerning pending or contemplated litigation and/or settlement offers included but not limited to the Ashish Patel case versus TDLR, and also advice from general counsel on legal matters pursuant to 5510712. It's now 9:07. We'll go ahead and bring this meeting back to order. At this point in time, we have nothing to discuss out of executive session. There are no items to take up at this point in time. Move on to item E, approval of the minutes. Commissioners, you had an opportunity to be able to review the minutes. I take a motion.
So moved to approve.
A motion second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's go to item F, F1, Jeremiah Hare, I believe. Is that correct? Is anyone here representing Mr. Hare? Mr. Sharp, proceed.
Morning, Commissioners.
Morning.
Morning.
My name is Ken Sharp. I'm the prosecuting attorney with the Enforcement Division. And the respondent in this case is Jeremiah Hare. He was first licensed as an apprentice electrician in 2004, and on July the 30th of 2015, he applied to renew that license. The department seeks to deny Mr. Hare's renewal application and to revoke his license based on his criminal history. The administrative law judge issued a proposal for decision that concurs with the department's position. In 2002, the respondent was placed on community supervision for 1 year after he pled no contest to a charge of theft, the value being from $500 to $1,500. And this charge was based on the respondent's theft of about $700 worth of merchandise from his employer at that time, Home Depot. He also obtained at least 15 different fraudulent refunds from Home Depot when he was employed there, and they were in the amount of about $1,200. Well, in 2003, the court revoked that community supervision and found him guilty and sentenced him to 25 days in jail. Then in 2010, the respondent was placed on community supervision for 18 months after he pled guilty to a charge of obstruction of highway passage, which is a reduced charge from driving while intoxicated. And in 2013, the court revoked that community supervision and sentenced him to 30 days in jail. In May of 2014, the respondent was once again placed on deferred adjudication community supervision, this time for possession of drug paraphernalia. He was originally arrested for possession of a controlled substance after undercover officers witnessed him purchase 2 bags of marijuana. In June 2015, once again, he was placed on deferred adjudication community supervision, this time for 4 years, and this time for possession of methamphetamine with intent to deliver. In June of 2015, the respondent was convicted of theft, the value from $500 to $1,500, and this conviction was based on his theft of some money. And although he was sentenced to 365 days in jail, the court suspended that sentence and put him on community supervision for 12 months. Now, also in June of 2015, the respondent was convicted of assault causes bodily injury family member, and as with the previous charge, the court suspended the sentence and put him on community supervision for 12 months. The offenses involving fraud, theft, and assault are all listed in the Commission's criminal conviction guidelines for electricians. The administrative law judge concluded that in light of the respondent's theft convictions, and one of which occurred while he was licensed, that the respondent would have the opportunity to engage in further acts of theft. And the ALJ concluded that the respondent would pose a continued threat to public safety. The ALJ noted that not enough time has elapsed since the respondent's most recent conviction to determine that he's now fit to be licensed. The ALJ recommended the denial of Mr. Hare's license renewal application and the revocation of his license. The department asks you to adopt the proposal for decision as it's written. Thank you.
Any questions for Mr. Sharp? A motion to be in order?
Make a motion that we adopt the PFD as written by the ALJ.
No. We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item 2, Ario Ja. Okay. And I believe you are Tony Pletcher.
Yes, sir.
Okay.
Commissioners,
Go right ahead.
Robert Minnick from the Enforcement Division. This applicant seeks a cosmetology operator license. On October 27th of 2004, the applicant was tried by a jury and convicted of 3 aggravated sexual assaults. There was 1 victim. The crimes occurred on May 19th, 2003. The victim was the applicant's 5-year-old stepson. The applicant was approximately 33 years old. I won't give you all the details unless the commission wants them of the specifics of the crime, but I can tell you that they involved digital penetration of the victim. They involved contact between the applicant's sexual organ and the victim's mouth. In the same trial, the applicant was convicted of 2 counts of injury to a child. These crimes occurred on the same day and against the same victim as the sexual assaults. Specifically, the applicant caused bodily injury to his stepson by hitting him in the forehead. The applicant also caused bodily injury to his 5-year-old stepson by squeezing the child's genitals. The jury, after the applicant had a full opportunity to defend himself, convicted the applicant of these 5 crimes. For the aggravated sexual assaults, the applicant was sentenced to 10 years in prison. For the injury to a child crimes, the applicant was placed on community supervision for 10 years. Significantly, the applicant had been a licensed cosmetology operator since 1989 when he committed the 5 felonies. Because he was sentenced to prison, the license was automatically revoked by operation of law. He was released from prison on October 24th of 2014 after serving his entire sentence. The applicant filed the application for a new cosmetology operator license in May of 2015, only 7 months after his release from prison. It should be noted that the parole board chose not to release the applicant on parole, even though they could have. We know he could have been paroled because during the SOA hearing, the applicant admitted into evidence several letters that were written in the mid-2000s to the parole board in an effort to persuade the board to release the applicant on parole. The ALJ recommends that the applicant receive the license. The department recommends that the commission reject the PFD, deny the application for a number of reasons. The applicant committed these reprehensible crimes in 2003. He was convicted in October of 2004. Between October of 2004 and October of 2014, he was in prison and unable to repeat aggravated sexual assault of a child because there were no 5-year-old boys in prison. Because of that, we have no way of assessing what he was like during those 10 years or how he would have behaved had he been in society for those 10 years. So we believe the amount of time between the commission of this crime and the conviction and today 10 years should be subtracted from that because there's no way to judge him during those 10 years. Only 7 months after being released, he filed the application before you. 7 months is much too short of a time to demonstrate that the applicant is no longer a threat to children. Additionally, the Texas Sex Offender Registry rates the risk level of sex offenders. The applicant is rated as a high risk. Finally, the applicant presented no evidence of sex offender counseling. The department urges the commission to find the applicant is unsuitable for licensure at this time. Take any questions you might have.
Any questions for Mr. Rennick? Mr. Pletcher, if you don't mind, state your name real quickly.
Sure.
Before you begin, at this point in time, the only thing that the commissioners can take into consideration is what was heard at the SOA hearing. Anything outside of that, our general counsel will step in and say that was outside the record, so we'll go ahead and shut the discussion down at that point in time from you. So just make sure you can find everything that was based in the SOA hearing. So if you don't mind, state your name for the record.
My name is Tony Pletcher. I'm a lawyer. I practiced for 41 years in Corpus Christi, Texas.
Go right ahead.
I am going to confine my comments to the evidence heard by the administrative law judge and to the evidence. And to put this in context, I live next door to the applicant's mother and father and have for 12 years. And until my client got released after completing 10 years of confinement, I had never met Dario, but I have live next to his parents, and he lives with his parents. And my grandchildren, my... Yes, it is. It is, yes, it absolutely is. So, to put this in context, we have never disputed the trial and conviction of the applicant. He has had his day in court. We presented the background circumstances to the offense. For instance, one of the things that the administrative law judge heard was that this stepson was engaged in a custody fight, and the grandmother of the little boy was allegedly putting him up to making an accusation. It was investigated, and we presented communications with the Department of Child Protective Services, where they chose not to take any action. But because of the custody fight between the grandmother and this child's biological father with the applicant's ex-wife, she was doing everything she could, we submitted, to poison the well. None of that makes any difference because that was rejected by the jury on the criminal offense, and he was convicted. But I think it's important for you members to understand the background of where this started. It's also, I think, very important to understand that the child's mother, who was formally married to the applicant, presented letters of recommendation to the administrative law judge on the fitness of her ex-husband, even in spite of the allegations that had been made and his conviction, that he was trustworthy and that he would not reoffend. And frankly, she didn't believe that the offense occurred to her son. Nevertheless, what we have is a conviction that is not overturned. We submitted not just letters of recommendation, but letters from the psychologists that tested the applicant when he was in confinement. And those reports indicate that he does not possess, in the psychologist's uncontradicted opinion, any interest in prepubescent boys. The evidence also that was presented by the administrative law judge is that the applicant's father and stepmother have run a salon in Corpus Christi for decades, that he worked there for 17 years before this event occurred, that the crime that he was charged with was the only crime he's ever been charged with. There has been no pre-arrests or post-arrest since he got out of TDC almost 2 years ago now. So with that background, this evidence that is basically uncontradicted went before the judge, who heard all of the live witnesses, considered all of the letters of recommendation, considered the psychologist's reports of the potential threat that he may have on society, and made a decision that if you read the provisions of the Licensing Act, he doesn't fall within the presumption because of the evidence we raised to overcome an admittedly heinous offense and conviction. The owner of the class act who bought the salon from the applicant's father has indicated that this salon is not one where young kids come in to have their hair cut. They can't come into that salon without a parent. The salon is open, there's no little private rooms. There is no evidence in this record that suggests that there is going to be a repeat of any offense. Just the opposite. And based upon the uncontradicted, overwhelming evidence, the administrative law judge made findings of fact and conclusions of law to recommend that this man be given a chance to redeem his life after he has paid 10 years of his life for the crime he was convicted of. And it has now been 19 months since his release, and I am certain if there had been even one hint of wrongdoing, it would have been brought forward. And the reason it wasn't is that's not the kind of person the applicant is. And he will not reoffend. And I humbly request that this commission follow the reasoning and analysis and findings of fact and conclusions of law by the administrative law judge that considered all the evidence in full. Thank you for your consideration.
Any questions, Mr. Fletcher?
I have a question. Can I ask you, Mr. Rennick? The applicant's attorney had said that their shop does not allow children without the presence of a parent. But correct me, is that license limited to just that salon, or can that license move with him?
It can go anywhere to any salon in the state of Texas. That's the argument I was about to make.
So it goes along with the reasoning that the commission has had in the past that even though this particular salon doesn't allow it, it doesn't mean that the applicant can't move to a salon down the street that does allow.
You can do it the day that you issue the license. You could go to work somewhere else.
And that was going to be my question to you, Ms. Fletcher, is to understand. I understand the business that you say he's going to be moving into, but that doesn't prohibit him from keeping the license and the next day moving to a different salon.
That is obvious.
Well, and so that being the case, the argument that he would not be in a setting that would give him the opportunity to reoffend is an argument that I don't buy, because he can be placed in a setting that he can reoffend. The other issue that I have is that he's only been out for a year and a half, just a little over a year and a half. And in my opinion, the fact that 10 years, as was stated, he was confined, but now he's out. The convictions that he had are egregious. They do, even I think the AOJ even stated that 3 of the 4 do fall under the offenses of the criminal code that would prohibit him from being able to get a license. 3 of the 4. So I find it difficult to be able to see him going out and doing this at this point in time. Now, I understand that it's not my opinion that he is forever to be banished from cosmetology. I just think there needs to be some more time built into there that he does exhibit that he is not, that he will not reoffend.
And Mr. Chair, I certainly don't mean to argue with the obvious that you have stated. But the fact of the matter is, this offense didn't occur in the setting of a salon. It came about in the setting of his child's home with where his mother lived. Secondly, the fact that we can't limit his license, we suggested that a provisional license be issued, but apparently that isn't available. So what we have, that the tough decision that you and members of this commission have to decide is, how long does a man with no criminal convictions accept, and it's a big exception for what he spent 10 years in TDC, how long does he have to wait to demonstrate with the reports that the administrative law judge considered from his psychologist that this man isn't predisposed to go after little boys? And so what we have to do is to rely upon the wisdom and common sense of not only the administrative law judge, but this commission on what is reasonable. If this man was going to reoffend, if he is a predatory criminal, he would have reoffended when he got out of prison, and he hasn't.
Okay, well,
Hang
Tana, I'm so confused by where this is going, because we don't, I mean, how could you assume, has there been an ankle monitor on him? If we had him watched by a camera every moment since he's got out, I don't know how we can make just bold statements like that, because we have no knowledge. And also, I'm trying to understand, did you not begin this whole conversation with the fact that he didn't really commit the crime?
No,
Or it just seemed
what-
like it was this whole muddy the waters, poison the well argument. I'm so confused as to what you're really arguing.
What I didn't mean to try to set aside the conviction of his crime. What I suggested was that the commission have the context of how this offense arose in a home, not in a salon, with his mother, who has presented evidence to this administrative law judge that she believed him and not her own son, with the understanding that CPS investigated it and wouldn't follow the recommendations that abuse had occurred.
That's what I'm trying to get at. So you're arguing that he didn't commit the crime?
No, I can't argue that. I can't argue the fact that he had his day in court and was convicted. I'm not going to take that position. But I think this commission, as the administrative law judge, has to view the totality of the circumstances, because the issue is the applicant fit currently with the conviction on his record? And what does the evidence show in front of the administrative law judge and this commission that is uncontradicted, that he doesn't have the predisposition? He has been a registered sex offender. If anything...
But that's because of his conviction.
Absolutely. It is because of the conviction. And yet he is free to travel up and down any road, visit any place, and he has not been even a hint of wrongdoing by any agency in Corpus Christi or the
Can I ask you a question, Mr. Pletcher? You've done a great job of advocating on behalf of your client. Obviously, the ALJ judge agreed with you. How old was your client at the time of the offense?
33.
33, so it was well into his adult years.
Yes, sir.
Okay. So he would have understood the seriousness of what was taking place at the time.
Absolutely.
And he had a cosmetology license at the time as well, correct?
Yes, he did.
And was, I mean, as a 33-year-old would be obvious to him, ramifications of any decisions that he made with regard to criminal justice and the impact it would have on his licensure, correct? Okay.
Mr. Fletcher, one of the things that, actually two things that I want to address. You state how long is long enough. I can tell you that in my opinion, 1.5 years is still not long enough. How much longer than after that? I don't know, and I can't give you a definitive answer on that. I just believe 1.5 years is not long enough. The second thing, you state that this crime did not occur in the salon that his parents own. I can tell you the majority of the cases that come before us, the crimes that have been committed did not occur at the workplace. So this is not the only place that we see that. The fact of the matter is that the crime occurred. Not that it occurred at the workplace, it's that it occurred, period. So that argument that you put forth of saying it did not occur in the salon, to me, doesn't carry much water. A crime is a crime. And that's the way that I view it.
Yes, sir. I respect that. I don't dispute that.
So, any other questions for Mr. Fletcher?
I have a
Shaw?
question for the counselor. On the finding of facts, number 31, a statement was made in there that cosmetology license will not provide an opportunity for Mr. Jakal to engage in further criminal activities of the same type as that which he was convicted of. Could you explain to me what, I mean, I understand what it means, but is the finding of fact stating that the cosmetology license will not provide an opportunity for somebody to create a crime like this?
It's hard to get into the mind of the ALJ who wrote that finding of fact, other than to say, based on the evidence of the witnesses who said that he would have all these protections at this particular salon, that's what the ALJ was referring to, that at that salon he won't have an opportunity. But to just generally say he won't have an opportunity at a salon, that flies in the face of the criminal history guidelines and of Chapter 53 itself.
Yeah, I'm like the chair. I think I agree that, you know, a crime like this could occur at the workplace. I mean, regardless of where and how the setup is made or how it's constructed. I mean, people do drop their children off at hair salons and go about doing their business and come back to pick their kids back up. I mean, I do that myself, so that is a possibility, so, yeah.
Well, just for clarification, the owner of the salon indicated that drop-offs are not permitted. Only children accompanied by an adult are allowed in the
That's
salon.
not a regulation that we regulate, or not a
That's
requirement that
her-
we regulate.
Yeah, that's
so.
the owner's, but I wanted to let you know that.
Thank you, sir.
Any other questions for Mr. Fletcher?
Can I make a motion?
Just, Mr. Rennick, did you have anything else?
I don't normally request to respond, but it is our burden in this case, and I would ask for it at this point, to respond to a couple of the points made by,
Is it a couple of points that we've already responded to ourselves?
no.
Oh, okay.
Okay. I just want to reemphasize that all of this could have been and probably was presented to the jury, and the jury rejected it and convicted him. Secondly, a mother defending a defendant over her child that's not the first time that's happened before this commission. We have many parents who have not supervised their children and have defended the individuals who were convicted by juries in cases before this commission. Third, there's been a lot of talk by counsel for the applicant about this psychologist opinion. I don't know that the commission realizes that this evaluation of the applicant took place 9 months before the trial of the applicant. And it was one interview of the applicant by this psychologist. And for the record, I'm holding up the letter. It's 6 sentences from this psychologist who just flat out declares that there is no sexual deviances and no sexual interests, fantasies about or future interests in young boys or girls. I mean, he might as well be Karnak to say something like this. Excuse me, but this is a joke of a psychologist's evaluation. And I hate to be so blunt, but I can't help it in this case. So I just wanted the commission to know that.
Mr. Rennick, you're showing your age when you say Karnak.
I know.
Yeah, I know. It's like, isn't it Johnny Carson?
And I'm proud of my age.
Can I make a motion?
Any other questions by the commissioners? Thank you, sir, I appreciate it. Mr. Yurko.
I also agree with my other fellow commissioners about the insufficient amount of time that has passed since release, and I move to change findings of fact 31, 34, 35, and 41, along with conclusions of law 10, together with some of the technical issues in findings of fact 3 and 33 because of the repetitive grammar errors, and deny the license.
And also finding the fact, one of those showed a date of 2014,
Yeah,
which
that was
should have
3
been
and 33.
2004. Just
Yeah.
So we have a motion on the floor.
Second.
A second. Any further questions? All in favor signify by saying aye.
Aye.
Those opposed? Motion carries 5-0. Thank you, sir. The, someone from the agency will be in contact with you or Mr. Jacoby and let him know, okay? Thank you. What your next options are. Okay. Yeah, they'll let you know what your next options are. You do have some further options, administrative. Let's go on to item F3. I believe we do have John Stevenson and Mark Wethor. Why don't you come on up here right quick? Mr. Rennick, go right ahead.
Commissioners, as in the last case, the department in this case seeks to deny the respondent's application to renew and to revoke his license. In this case, it's a journeyman electrician license. Prior to receiving it in 2011, the respondent held an apprentice license for a year in 2006 and for a year in 2010. He allowed both those licenses to expire. The respondent's criminal history is as follows. In 2004, he was placed on deferred adjudication for possession of marijuana. In 2005, he was convicted of misdemeanor theft. In 2008, he was placed on deferred adjudication for 5 years for 2 felony thefts. In 2011, he was convicted of misdemeanor theft. Then in February of 2014, he was convicted of 2 misdemeanor thefts and the crime of fraudulent removal of a writing, which is a misdemeanor. Finally, in September of 2014, he was convicted of felony theft of copper wire and sentenced to 60 days in the Dallas County Jail. All of the 2014 convictions were committed while the respondent was licensed by the department. 2 were committed in 2013 and 2 were committed in 2014. The most serious crime was the last one, which involved the theft of copper wire and was committed in June of 2014. The department discovered all of the 2014 crimes in May of 2015 when the respondent filed the renewal application that is before you today. We also discovered that the respondent answered no to the criminal history question when the truthful answer was yes. At his administrative hearing, the respondent testified that a meth addiction compelled him to steal for 15 years. He added that he changed his life in the summer of 2014. However, the respondent falsified his renewal application in May of 2015, approximately 9 months after he allegedly changed his life. The respondent was born in 1980. He was approximately 24 when he committed his first crime, and he was approximately 34 when he committed his last. The ALJ recommends that the Commission deny the renewal application and revoke the license because the respondent committed 9 crimes over a 10-year period, because of the nature of those crimes, because of how recently the last crime was committed, and because the respondent falsified his renewal application in connection with the application that is before you. The department recommends that the Commission adopt the PFD, deny the renewal application, and revoke the license.
Any questions for Mr. Rennick? I believe I have Mr. Is it Stevenson?
Stevenson.
Stevenson, okay. I see the S now. Okay. Stevenson and then Mr. Wethor. Okay. Again, I'm sure you probably heard before, the only thing that we can take into consideration is that was presented at the ALJ hearing, at the SO hearing. So make sure that you confine your remarks strictly to that and not bring anything outside into this discussion. So, if you don't mind, state your name for the record.
John Stevenson. I'm an attorney for Mark Wethor.
Mr. Wethor, are you going to be speaking also?
Yes, sir.
Okay, if you don't mind, when it's your turn, state your name also. Go right ahead, Mr. Stevenson.
Yes, he was granted his journeyman electrician's license in 2011. At that time, there was notice of these past convictions, and from my understanding of the law, there's a renewal process each year after that, and it was renewed every year until 2015, and an argument I had at the ALJ hearing was that estoppel should control in this issue, like specifically quasi-estoppel as stated by the Texas Supreme Court in Lopez versus Munoz. It prevents a party from asserting to another party's disadvantage a right inconsistent with a position that it previously took, and the previous position with all these renewals is he was capable of practicing his trade, and it granted him a license.
Did he answer no to the question of he'd been convicted?
Yes, in 2015.
So he basically obtained his license under false pretenses, though?
I think it was just 2015, the others.
That license hasn't been granted. He attempted to.
Attempted, oh. It's my understanding that he checked yes on those. And then it was 2015 when that no was checked. Since that time, since his last conviction, he was in rehab for 9 months, with the first part being inpatient. He's been clean since then. He's reunited with his estranged wife, who, as my understanding, they'd been apart since his addiction took control, and he's now reunited with her and his 2 kids. And he is practicing his trade until this time with a reputable electrician company who also wrote him a letter of recommendation. They knew of his past, and I still took the risk to hire him. He's, my understanding, he's been taking drug tests and meeting with his parole officer when required, and there have been no further incidences since these convictions. And right now, we're just asking that he be allowed to keep his license, since he is now clean and able to start his new life. This would take away his livelihood and make it even harder to stay on the straight road.
Well, so you know, the ALJ found that he was not fit to carry a license at this time.
Yes.
And I would argue that we're not taking away his license, he did.
Yes, I understand that.
Anything else? Mr. Wethorn, you have something to say?
My name is Mark Wethorn II. I'm not denying or justifying anything that's happened. I'm just asking that y'all could please give me a chance. I mean, God's gave me a chance. I've overcame so much. And I'm just hoping that y'all can just, see in your hearts to please give me a chance to show you that I'm not a failure. I'm not going to fail myself or my family.
Mr. Wethorn, I have a question.
Yes, ma'am.
Okay, back in '08, were you not given a chance with a deferred adjudication?
Yes, ma'am.
Okay. And then, when you were reapplying, did you consider the deferred adjudication not a conviction?
That's what I thought. I didn't think it was a conviction.
Okay, but then in 2014, was that a deferred adjudication, or was it an actual conviction?
That's a conviction.
And is that the application that you were not truthful on?
The thing was that at the time, my defense lawyer said it wasn't going to be on my record. But after going through this process.
What wasn't going to be on your record?
What I did in 2014.
But it was a conviction.
I understand that now.
Okay, I understand, but when you did the application, did it not state, have you ever been convicted?
Like I said, before all this process, I thought that it wasn't going to be a conviction. I thought.
I understand what you thought. I mean, I'm not knocking
Yes, ma'am.
that, but I'm
Yes,
saying
ma'am.
when you got to the point that you had to swear to that application.
At that point, I thought it was not a conviction. I thought I was going based on the defense lawyer. But then after going to the LAJ, is that what?
ALJ.
Yes, sir. That's when they're like, no, that's a conviction. You needed to put, it was a goof, I'm sorry. I just,
And you've been sober for how long?
since June 28th, 2014.
Which is marvelous.
I was gonna say,
I think that's
commend you
great.
for
That is marvelous. But I think you need a little bit more time personally to prove yourself before being allowed to be put in the situation again.
Yes, ma'am.
And I agree. I mean, I would concur with Commissioner Yurko. I think it's admirable, the fact that you have come clean and that you've reunited, which is great. It sounds like you've got your life back on track,
Yes, sir.
which is good, and I tell you, that's the most important thing. I agree, I think it's still too soon, in my opinion. It doesn't say that you can't come back and apply again. I just think we need some more time between the last conviction when you got out and when all that ended to the point in time that you can actually get your license back.
It's been almost 2 years now, so.
And I'm proud of you.
Yes, sir.
I still think it needs a little bit more time, simply because of the number of convictions that you had in that 10-year time frame. It's quite a few.
Absolutely.
And so, but again, I commend you for getting your life back on track. Any other questions or comments? Anything else? I'm sorry.
I would. I'd like to address the application. Mr., how do you pronounce your name? I'm sorry.
Wethorn, sir.
Wethorn. I'd like to follow up with what the other commissioners have said. I'm glad you're on the right track, but you know, you've created the life that you've lived, and where you are is the sum total of the decisions you've made in your life, and so you need to own that to get behind it, and don't run from these convictions. I mean, this is who and what you are, and if you're really going to come out on the other side, a changed man, you can't run from it. And so when you decide to say that you've not been convicted, you're lying to yourself. You're certainly not lying to us. I mean, so I'm glad you're on the road that you're on, but you need to make it real. Yeah. And your family deserves better than that, too. All right.
Any questions, comments? Anything else from either one of you? Thank you. Feel free to have a seat. Mr. Rennick, anything else?
No.
We'll go ahead and close it. At this point in time, any discussion or motion will be in order?
I'm gonna go ahead and make a motion to adopt the PFD as presented.
We have a motion on the floor.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed?
No.
Motion carries 4-1. Let's now go on to F4. Mr. Rennick, is that you?
Edgar Ozario?
Yes.
Yes.
Is anyone here for Mr. Ozario or representative? Thank you, sir. Appreciate it.
Appreciate you.
Go ahead, Mr. Rennick.
Commissioners, the department seeks to deny this respondent's application to renew his apprentice electrician license and revoke it. He was originally licensed in May of 2013. In June of that year, the respondent pled guilty to possession of marijuana and was placed on deferred adjudication for 18 months. The crime was committed in June of 2012. In 2014, his community supervision was revoked and he was sentenced to 30 days in jail. On September 4th of 2014, the respondent was placed on deferred adjudication for 7 months for indecent exposure. The crime was committed on July 17th, 2013, only 1 month after he received deferred adjudication for possession of marijuana and only 2 months after receiving a license from the department. The respondent, while sitting in a car, intentionally exposed himself to a 22-year-old woman. She called the police. When they arrived, the police asked the respondent what he was doing. He said, quote, something naughty, close quote. The police then asked if he was masturbating, and the respondent said he was and that he couldn't help it. The respondent was born in 1989. He was approximately 23 when he committed the marijuana crime and approximately 24 when he exposed himself. When the respondent sought to renew on August 6, 2015, he answered no to the criminal history question when he should have answered yes. The respondent presented no evidence of sex offender counseling. The ALJ recommends denial of the renewal application and revocation of the license because of how recently the crimes were committed, because of the seriousness of the indecent exposure offense, because he intentionally falsified his renewal application, and because of the overall lack of rehabilitation evidence. The department recommends that the commission adopt the PFD, deny the renewal application, and revoke the license.
Any questions for Mr. Rennick? Motion be in order.
Motion to adopt the PFD?
Second.
A motion is second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carries. Item
Mr.
5.
Mr. Chairman, I believe it's Brad Bowman. I believe the respondent is present. I don't know if he intended on speaking
Ozario?
or.
Oh, I'm sorry. I called out. I didn't hear you. Do we have a sheet for you? Did you fill out one of these?
I didn't really want to say anything.
Okay.
I was here to listen.
That's fine. If you don't want to say anything, we're fine. All right. Item number 5, Mr. Gonzalez. Is anyone here representing Mr. Gonzalez? Mr. Rennick?
Commissioners, the department seeks to deny the respondent's application to renew his apprentice electrician license and revoke it. In 2013, this respondent was convicted of theft twice and criminal trespass. He was sentenced to 3 days in jail for one of the thefts and 75 days in jail for the other. The criminal trespass, he was sentenced to 75 days in jail. All 3 crimes were committed in 2013. In July of 2014, the department took a chance on the respondent and issued him a license. Then, on November 14th of 2014, only 4 months after receiving the license, the respondent committed theft of copper wire, a felony. He was convicted on August 20th of 2015 and sentenced to a year in jail. He was born in 1990. He was approximately 23 when he committed his first 3 crimes and approximately 24 when he committed his last. When he filed his renewal application in October of 2015, he answered no when he should have answered yes. The ALJ recommends denial of the renewal application and revocation of the license because of the seriousness of the respondent's crimes, how recently they were committed, and the false answer on the renewal application. Department recommends that the Commission adopt the PFD, deny the renewal application, and revoke the license.
Any questions for Mr. Rennick?
Yeah, I'm just kind of curious. Mr. Rennick, did we actually give him a chance? Did it come up on a revocation and we sided with the applicant? Back before, when you were saying in 2013 he applied, we gave him a chance and gave him in 2014? Was that
No,
an
he
in-house
had those 3
decision?
misdemeanors when he applied. He had
Yeah.
that in his criminal history.
Right.
Yet we took a chance on him and gave him the license. He didn't have a license before.
No, I agree. I understood that, but I was trying to figure out who took the chance, the staff?
Probably would have
or-
been me.
What's that?
Probably would have been me or the licensing division. I don't know, but I'll take responsibility because I don't know.
No, I thought that was refreshing. It was just a nice thing to point out. I
Oh,
was
yeah,
just
yeah.
trying to
I'm
figure out.
guessing it was probably
Yeah.
me. I just don't want to.
Now you're
No,
gonna
no,
take
no.
credit, right?
One drop in
Oh, yeah,
your
that was
cup.
me, that was me.
No, one drop in
It was
the
me
crease.
either way.
No,
Well,
I
that's a
just,
good thing or a bad
I just
thing?
thought it was refreshing.
Okay.
Anyways, okay.
I consulted Karnak on that one.
Yeah. I was giving you a slow pitch.
Thank you. I appreciated it.
Okay. Motion to
Very
deny and revoke
appreciated.
the license.
I'll second that.
A motion is second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's go on to the motions for rehearing. I believe we do have, is it Myra Ortega? You are present, come on up. We have an interpreter?
Okay.
Let's go ahead and begin, Della, with the first one.
Good morning, Commissioners. My name is Della Linquist, Deputy General Counsel. I didn't know if you wanted to repeat everything, how I'm saying it, or just to let her know.
Yeah.
This is a default case. We had mailed notice to her, to the correct address, and assessed a penalty against her for $1,000 on March 8th, 2016. Her license was revoked. Her cosmetology license was revoked in the default order. However, since that time, Ms. Ortega has paid the $1,000 in full. And though we believe, the General Counsel believes that there was no error on the part of the department, we recommend still denying the motion for rehearing, but to be consistent with what we've done in the past, probate that revocation for 1 year because she's paid in full. So she would be allowed to work, continue working, as long as she minded the rules and the laws for her cosmetology license throughout that year.
You might, of course, state your name right quick for the record.
My name's Mayra Enriquez, and I'm with TDLR.
Might have let her know that, based on the recommendation of our general counsel, I don't know if she still wants to speak or just simply take what we've got.
Ellos recomiendan de que te dan la licencia por condiciones que si quieres puedes hablar todavía o puedes aceptar. Todavía puedes trabajar, te van a dar la licencia pero con la condición de que estés al corriente con todo, trabajes bien, todo legal, sin multas, sin fallas, sin reducciones con tu licencia. Esto significa que puedo, como no estar en un salón, o puedo todavía poder cuando quieran estos meses abrir un salón. Does this mean that at this time I can just work in one specific salon, or can I still operate my license fully, like as a cosmetologist?
Should we operate fully?
Completamente como si fueras cosmetologist. Nomás va a ser un año que tengo que estar como sin tener ningún caso pendiente. This is just for 1 year that I stay, you know.
Clean?
Yeah, clean and violation free.
Right.
Well, hopefully longer than that, but.
Right, from here on out, but we'll look at it for a year.
Okay. Sí, nada más van a ver la licencia por un año que estés. Esperan que después no haya más violencia.
No, we have to grant the motion for rehearing and then
At this time, what is it that I actually have to do?
Okay, so the question is she willing to accept what they said, or does she want to go and present her case on the default?
¿Quieres aceptar lo que ellos te van a ofrecer?
Okay, so let's go ahead and move on to the recommendation of general counsel.
Well, we recommend you deny the motion for rehearing. What you've done in the past in cases similar to this is probate that revocation for 1 year, conditioned on the fact that she's compliant with all the rules and laws. Her license could be revoked in full if she fails to abide by the laws and rules within this 1 year.
You might let her know that.
Okay. So, lo que te están haciendo te van a dar tu licencia, pero es con condición de que estés limpia de todo, sin multas, sin corrupción. Si llegas a faltar en este año que ellos van a estar observando la licencia, entonces en ese tiempo ellos te la pueden quitar como si no te hubieran dado esa oportunidad. So tienes este año para mostrar buen carácter.
She's okay with that. All right, so we have a recommendation by general counsel to deny motion for rehearing, but probate the revocation for 1 year. Can we get a motion to that effect?
So moved.
Second.
Motion is second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. I would note that Commissioner Yurko did voice to me that she was in support of it, but she's not here. So, all right, let's move on to thank you. Muchas gracias. Let's move on to item 2. Let's move on to item number 2.
This is also a default case in which notice was not challenged, or
Thank you.
the respondent didn't allege that the notice was bad. He simply, in his motion for rehearing, alleged some factual allegations and challenged them. We recommend that you deny the motion for rehearing. We did not see any error in the process.
Is anyone here representing, is it Ricky Hyde-Tron? Commissioners, you have a recommendation on the floor?
Not a motion for rehearing, sir.
We have a motion?
Second.
Second, all in favor signify by saying aye.
Aye.
Motion, all opposed, motion carries. Item number 3, Andrew, is it Wojtek?
This is also a default case. In Mr. Wojtek's motion for rehearing, he questions some of the allegations. However, he didn't challenge the notice or allege that notice was bad. He had an opportunity to ask for a hearing, and he did not. We recommend denying the motion for rehearing.
We have a recommendation by council. Anyone here for Mr. Wojtek? We have a recommendation? A motion will be in order.
Move to deny the motion for rehearing.
We have a motion. Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 4, Federico Rodriguez.
This is also a default matter. This respondent appeared to have negotiated or attempted to negotiate a settlement during the pendency of this case, during the time the NOAV had been sent. However, apparently it didn't, it kind of fell apart, so there's no settlement, and he sent some documents back and forth. Ultimately, we sent the notice of default to the correct address. He did not ask for a hearing, so we recommend denying the motion for rehearing.
Anyone here representing Latino Transport? We have a recommendation by GC.
Motion to deny the rehearing.
Motion. We have a motion on the floor.
Second.
And a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Number 5, Fernando Alanis.
This is also a default, actually, this is a default matter based on a revocation of his tow license for failing to make good or complete payments on a previous agreed order with the department. He paid approximately $250 of a $1,500 agreed penalty. He still owes approximately $1,250, and he hasn't paid on that. There was an attempt by our office to reach out to him to continue payment or something, but he did not respond. So we recommend denying the motion for rehearing.
Any questions or any recommendations on the floor?
Motion to deny the rehearing.
We have a motion.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, Della. Hair looks great, by the way. Item H, an update on the strat plan. It's an inside joke.
Commission members, Brian Francis, Deputy Executive Director with TDLR. I just want to give you a very quick update on the strategic plan. First of all, it's going very, very well. We've completed all of our external focus group sessions. We've completed all the internal focus group sessions. So we have quite a bit of data that we're running through. We will be wrapping up our editing of the document this week. We'll provide a copy to the commissioners for their evaluation on the 24th, and they'll have through June 8th to make their recommendations and send it back to us so we can incorporate it. We will then bring the final document to the commission for its approval at its next meeting. I believe it may be June 22nd, and then we will file the strategic plan on June 24th. So we've got a lot of stuff happening very quickly. Keep in mind that the strategic plan this year is going to be a lot shorter. It's going to be 20 pages, not counting the appendices, so it's very tight. You're going to see a more focused document. There are 2 new sections that are included in there. One deals with the schedule of removing impediments and redundancies. I will just tell you that what we're working on is going to be very, very impressive in identifying possible statutory changes that will make it better for people who are trying to get licensed, to remove impediments that deal with reciprocity, but also looking at license types and programs that may not need to be licensed or regulated by TDLR anymore. So we've got a very exciting opportunity there. The other new section is dealing with goals. So normally every agency has goals that are given to them by the Legislative Budget Board and the Governor's Budget Office of Planning. And during this strategic planning process, they've given each agency the opportunity to create its own agency goals. And we've identified 5 key goals that we think will set our agency up going forward till 2021. Whether it's dealing with our outreach and communication to our licensees, whether it's dealing with constantly looking at removing impediments and redundancies, or even just the simple little tasks that's on our plate of consolidating the 14 new programs that have been given to us. So we've got some very targeted goals with specific action steps as well as dates that those will be completed. And then finally on May 3rd, Bill, myself, Tony Cuvion, and Michael Kelly attended a training for zero-based budgeting. This ties to the strategic plan because the LAR is going to have some of that molded into it. We had a presenter from Georgia that's done a really good job in incorporating zero-based budgeting in their process. The first thing she acknowledged is that no one does zero-based budgeting, but they do a mix of it. And in Georgia, they do about 10% of the agencies and programs within those agencies to say, for this slice of your business, do a zero-based budget. But they still do incremental budgeting, performance budgeting, and strategic planning budgeting. So we're imagining that we'll have some type of mix of that. We've not received the instructions for the legislative appropriations request, but we've not been sitting idly. So we're already going through the process of evaluating what our budget can look like going over the next biennium. So a lot of work going on. The staff's been doing great. Bill's been in the drafting meetings, but he's been shooting spit wads at people But when you unravel the spitwads, it has these wonderful nuggets of wisdom, you know, so.
You seriously want to say that? I would also make note that in our last meeting, we I assigned a subgroup of myself and I believe Commissioner Rodwald, Commissioner Shaw, which we will receive a copy of a draft of the strat plan for us to review. But when the plan is submitted to the entire commission and the commissioners, I would ask the commissioners to review that carefully because we will be on such a tight timeline. We're going to ask that when we come in on the 22nd, that's because we want to have a final draft done. So if you have any questions or comments on the strat plan, you're going to need to submit that to Bill and Brian prior to the June 22nd meeting, because at that point in time, the book is closed, the ink has been put up, and there's no other changes to be made
So
to it.
when would we get that plan then?
You're gonna get it
It'll
on May
probably be-
24th.
Yeah, it's due, you'll get it May 24th.
Yeah, May 24th, the commission will have
No,
all.
that's awesome, because we'll at least have a few,
Sure.
I just didn't want to get it the night before. and-
Absolutely, yeah, you're
okay.
gonna have May 24th
Well,
through June 8th to do your edits and kind of
Yeah.
work on that and get it back to
The
us.
tradition of giving documents to commissioners the day before, I think, has come to an end.
Those days are done.
Those days are
Thank
done. We
you.
decided that that doesn't work out very well anymore. So, yeah, we'll get it before that. So,
Absolutely.
anything else?
And, Mr. Chairman, the other parts of the executive presentation, new program bill implementation.
Bill, excuse me just a second. I'm going to hold off on that part. Can we bring Jerry up and have him do his spiel? The reason is because we're going to go back in executive session. When we come out, we'll get your report.
That'll be good.
Are you okay with that?
Yes, yes,
Thank you, sir. Jerry, come on up and give me your department report.
I'm Jerry Daniels with the Financial Services Division. I have bad news and good news. The last financial quarterly report that we presented to you as of February 29th, I believe, showed that we had spent 50.3% of the budget in the first 6 months. Since that time,
That's bad news. We're over .3.
we were at that time. Well, according to the budget that we presented. But at the end of January, and we didn't include these figures in the quarterly report, at the end of January, we were given money for both the new dishes programs and for the DES. We had already budgeted the DES money because we knew we would get it, we just weren't sure when. But with the additional $2.5 million that we got for the dishes programs, we're in good shape. So that's the good news.
So now we're below 50.
Now, yes. Well, we're below where we should be at the end of April. I did want to bring you up to date on the conversion of the Versa program. That was a really complicated, and it's still complicated, massive presentation that we had to do to submit the SOW under the new Senate Bill 20 rules and regulations. It did go forward, and it's on track for the conversion at October 3rd, which will be the first working day in October of 2016. The other thing I wanted to talk to you about was the conversion of our accounting system to the Capital Accounting and Personnel Payroll System, otherwise known as CAPS. The CAPS program is set to be the new ERP program for the entire state. Prior to this year, when we started, there were probably, I think, 8 or 10 programs that are currently on CAPS, or 8 or 10 agencies. This time around, there are another 8 that are going, and we're one of the 8 that's going to be converted to CAPS. I had hoped that once we got on CAPS, that would kind of replace USAS, which is our current accounting program. But what's going to happen, we're going to be on both programs until all of the state agencies can convert to CAPS, and there's 200 agencies. So it'll be, I'm not sure I'll still be with the state when that happens. But the thing about the CAPS program is it's a great program. It's gonna produce some efficiencies for us in the expenditures and purchasing area. And that's basically what most state agencies are concerned with, is spending money. But as a licensing agency, with, you know, the various programs that we have and the fact that we have to cover our cost, we spend a lot of our time and effort on the revenue side of the program. And we have to identify the revenues per program so that we can set rates accordingly. And that part is not as well developed in CAPS as we would hope it would be. So we're going to have to kind of twist and turn and twist and turn what we're currently using in USAS to make it work for CAPS. So it's going to be kind of a challenge on the revenue side.
And that's also going to include, we said human resource down the road?
Ultimately,
The
yes.
next biennium.
Next biennium, okay.
Yeah.
All right. Any questions for Jerry? Maybe we can keep him here until we get that completed. I don't know.
Thank you, Jerry.
Appreciate it.
You did a great job, Jerry. Thank you.
I would also make note, since Jerry was up here, the Finance Audit Subcommittee that we had consisted of course, Commissioner Yurko, but it was former Commissioners Morgan and Moses. So, Commissioners, if you're interested in serving on the Audit Finance, let me know, because we'll have to appoint a different subcommittee for that. So,
You replaced me too?
you're irreplaceable, Commissioner Yurko. At this point in time, I'm going to go back up to item C, in under section 551071 of the Government Code, discussion of personnel matters, including but not limited to the appointment, employment, compensation, evaluation, reassignment, duties, discipline, retirement, and dismissal of the executive director. So at this point in time, it is 10:14. We're going to go back in executive session.
Okay.
take a couple of items up for consideration. One of the items is the acceptance of the retirement notice of Bill Kuntz, effective August 31 of 2016. So it is, you know, if we don't have a motion for it, I don't really know if
Oh, that's right. Works for me.
So, anyway, it's unfortunate that we will have to consider the item, because I think Bill's gonna leave no matter what.
Yeah, Mr. Chairman, this is reminding me of my Army service, when they were needing the officers for the Vietnam War, and they were pushing us. I'd signed up for ROTC for 4 years, and then they were pushing us to sign up a new contract that said voluntary indefinite service, which meant that they could hold you as long as they wanted. So I hope that I'm not facing that right now.
It's possible.
Mr. Chairman, I think I'm going to go ahead and make the motion. This is extremely difficult to make this motion. This is probably one of the most hardest ones that I've made since I've been on the commission. But on behalf of all the licensures, the TDLR staff, all the previous commissioners that have been here, the staff that has retired from here, I want to thank you for all the work that you've done, Bill Kuntz. You've been an inspiration to many. You have led this department, this agency to greater heights, and I think you've brought this agency to many legislators and brought it up to their eyes that this is an important agency for all the economic development that goes on within the state of Texas. So thank you very much. So with that, I make a motion to accept Bill Kuntz's retirement notice to us.
We have a motion. Again, no one has a second.
I will very reluctantly second, but tell him that retirement can be an awesome thing.
We have a motion and a second to accept the retirement notice of Bill Kuntz, which will be effective August 31 of 2016. Before we take the vote, I can tell you that it has been an extreme pleasure of mine for the last 11 years to work with you, Bill. I know that we still have a few months left, so I think instead of calling once a week, I'll start calling twice a week to visit with you. But I look forward to even past that, of knowing that whenever I do come into Austin, I have somebody here that I can visit with, have lunch with, and even to be able to share a steak with in the evening, as we have done in the past. So you have been a pleasure to know, a pleasure to work with, and I can tell you I proudly call you my friend.
Thank you.
So at this point in time, all in favor signify by saying aye.
You lead us, Chair?
Aye.
That's good.
I vote no.
I vote no.
I vote no.
And I vote no.
So I'm just, again, please understand, we're kind of going away from Robert's Rules of Orders, because that's a 1 to 4, so, but.
Chairman, that means you have to ask for another motion.
We'll accept another motion at this time.
I will go ahead and make the motion to accept Bill Kuntz's retirement notice.
And I'll second it.
All in favor signify by saying aye.
Aye.
Those opposed? Thank you,
No.
Bill.
Thank you.
We do have another item to consider with the acceptance of the retirement of Bill Kuntz effective August 31. Is there a motion to bring forward before this commission at this time?
I'll make a motion. I would like to move to nominate Brian Francis. Appoint Brian Francis as our executive director effective September 1.
Second that motion.
We have a motion, a second, to appoint Brian Francis as the new executive director beginning September 1 of 2016. I would add, and just for purposes of minutes, that it would be at the rate of $179 $375 as an annual salary. We had to put that in the minutes. So I think that,
Yep.
are you accepting with that?
The
The
addition?
second's okay? So, all in favor signify by saying aye, or we can go with the noes first if you want to do that one. Brian, I tell you, I look forward to having you on. You have been a mainstay and steadfast for this organization. I think the employees will find that you will continue to be who you are, just in a elevated role. I look forward to the energy that you're going to be bringing to that position. And I say now to all the employees, let it be heard that the commission backs you 100%.
Let's do that vote, so
So-
they all hear it.
All in favor signify by saying aye.
Aye.
Aye. All opposed? Motion carries. Congratulations. I think that covers any action out of executive session. I think we've got it covered.
Mr. Chairman, I want to thank the commission for making my departure easier, that I know that the agency's being left in good hands.
I agree. We do have the executive director report. I'm not sure if you're in a position to be able to say anything. I can move on to public comments, allow you to be able to gather yourself. We'll move on right quickly to J, which is public comment. If anybody's here would like to speak before the commission, then we will give you the opportunity to speak. You'll have 3 minutes in which to speak. There being none, come forward. I would also move on to item K, which is the date discussion of our next meetings. You received an email from me due to some scheduling conflicts that our newly appointed future executive director and I have in a conference that we're attending. We asked that the meeting be moved to June the 22nd, which we will. I would also make note that that is when we'll also elect a new vice chair. We do have 2 dates that we were looking at, June the 13th and the 20th. We've now moved that to June 20th or 27th, I would say, of July. So we're now looking at either July 20th or July 27th. I can tell you that the new commissioner, Rick Figueroa, has already stated to me that the July 20th meeting, he will be at the National Republican Convention, so would not be in attendance. Asked that if we could possibly move it to the 27th, he would really like that. I think since we're moving the June meeting back, I would be encouraged to say that the 27th may actually work out better for us if everyone's in attendance for that.
I will not be, but I would not be for either week.
Oh, okay, so you're out either way.
Yeah.
Okay. Does anyone else have a scheduling conflict for the 27th?
Of July? No.
July? Okay with those dates? Okay.
But I do have for the 22nd, but you already knew that.
Right,
That
yeah.
I'm out of the country.
Right. So let's go ahead and solidify our date of July 27th. And I would also tell you that we want to have a meeting either August the 24th or August the 31st. I can tell you, just to be mean to Bill, I say we need to have a meeting August the 31st, which is his last day here.
That would be fun.
You won't be here for the 31st?
I could do the 24th.
What about the 24th? Is everyone
I
here
can
for
do
the
the 24th,
August?
I think.
August the 24th? So why don't we look at August the 24th? So we now have June 22nd, July 27th, August the 24th. And depending on what's going to be happening, you could probably look at a date in the first part of October for the next commission meeting after that. So, which puts us at around, bear with me. Probably around August the 5th. I'm sorry. I've got on my,
what's for
October the
August?
5th.
Oh, okay.
My apologies. I've got all my months confused here. So look at the next possible date being October the 5th. Okay? Now, I've given you time to compose yourself, Bill.
Thank you, Mr.
Let's go
Chairman.
back to the executive director report.
Bill Koontz, your executive director. First of all, I want to call your attention to the boards. One, we've got a new board that's going to be visible to the commissioners, so you don't have to try to look over your shoulder to see what's being put on the board. This is the letter from Governor Abbott this morning to the Secretary of State, making the appointments of Rick Figueroa and Helen Collar. The requirement is that the governor has to be in the state to make that type of decision, and he was back in the state today. So the appointment is as of today's date. I'd like to call your attention on the cease and desist orders and the agreed orders. I have 4 agreed orders that are in this packet. They're on pages 32 and 33. They are agreed orders with the licensed breeders that we've had several cases that have come forward. They had entered into the agreed orders. And with the licensed breeders program, the penalty fees that are paid in those agreed orders go to that program to help pay for education and the operating of that program. So that helps us in 2 ways. One, it lets the breeders know that we're watching. It brings the people that are out of compliance into compliance, but also helps fund that program, which is a really good thing for us because we just don't have that many licensees in that particular program. The presentations that we've had, we had a meeting with Chairman Larry Gonzalez. He's the new chairman of the Sunset Commission. He was wanting to know how the implementation was going for the transformation of the Department of State Health Services programs sent to us, those 7. We were able to give him a real good report on that because of the progress that we're being made. One of the things that we're waiting to finalize, though, is that when the funding was held up with the rider and trying to sort that out, the Department of State Health Services did not receive any appropriations for operating those programs. And until February, we did not receive any appropriation for that. Because we had money that would have been coming to us during that operation where we're not actually doing the licensing of those programs, we've entered into, or attempting to enter into, a memorandum of understanding to transfer some $600,000 to Department of State Health Services to pay the salaries of the people that are actually doing the work right now until we get that transformation completed. We're going through the process of dotting the I's and crossing the T's on this. Brian and I kind of thought it would have been a pretty simple thing that said, we're going to give you $600,000. Will you enter into a quick agreement with us so that we can get that done? And we got a pretty voluminous document back from Department of State Health Services. They're a larger bureaucracy than we are, so they move at a little bit slower rate. So we're there waiting to help them out with their appropriation when they are able to get their paperwork together for us. I did a presentation with the Executive Leadership for Information Technology, the ELITE program. That program is one where I and 2 other individuals act as legislators, and the people that are in that class come and make the presentations to us. It's kind of a fun role reversal because I've always been the one making presentations to the legislature. And in that, we're supposed to do all of the dirty tricks that you run up against, where a phone will ring and the legislator gets up and walks and takes a call, or somebody comes in and has a meeting for a constituent, so they leave the dais, and all of a sudden you're talking to nothing but the empty chairs for the legislature. It's a test to see whether somebody can keep their wits about them and keep the presentation going, because their staff is there listening, and it's also recorded. So you've got to not blink. You've got to be able to go through that. So it's been a fun project on that. And then the Texas Fiscal Officers Academy, Brian was an instructor for that, and that's done by the comptroller to teach people how to do their legislative appropriations requests. So we've been busy doing outreach to other agencies to kind of share the knowledge of TDLR, and that's been a real good process for us. And it's fun to get out and talk to the other state agencies. Those are the highlights that I've got from the Executive Director's report, if you have any questions.
You know, I think we're going to reserve all of our questions for August 24th. Any questions for Bill? All right. I think that we have covered all of the agenda items. Is that correct, Kay?
Yes, sir.
So it is now 12:44, and this meeting's adjourned.